Blake Lively wants to begin gathering additional evidence in her lawsuit against Justin Baldoni, but his legal team is saying, not so fast. Your demands for material are way too much and are just a media ploy and maybe potentially aimed at intimidation. We're going to break down this new conflict between the two stars. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Another battle is brewing in the ongoing conflict between Justin Baldoni and Blake Lively. This time it is about subpoenas. Now, we talked about the start of this last week, how Lively has gone on the offensive right now. As Lively, as we know, she has sued Justin Baldoni, her co-star, director of It Ends With Us, the film that they were in together. She also sued his production company, Wayfarer, executives, PR, and crisis management experts that apparently worked with him, all alleging that Baldoni sexually harassed her and then launched a retaliatory smear campaign against her. And as Baldoni fired back in a lawsuit against her, her husband Ryan Reynolds, also suing the New York Times, his argument is there was a coordinated effort to destroy his reputation with false allegations that he says were weaponized against him for Lively to essentially get control of the movie, take control of all aspects of production to get her way. And as all of this is going on, it was reported that Lively's legal team sent out a bunch of subpoenas to companies, one of the first steps in any kind of litigation. In fact, we talked about this last week, but her attorneys, Ezra Hudson and Michael Gottlieb, said in a statement that was published in The Hollywood Reporter, quote, "Ms. Lively has initiated discovery that will expose the people, tactics, and methods that have worked to destroy and bury her reputation and family over the past year. We will now receive all of the receipts that, unsurprisingly, are nowhere to be found on Mr. Friedman's website, and like Ms. Lively, those receipts will have their day in court." Now, this is referring to Baldoni's attorney, Brian Friedman, and the website that was purportedly launched by him and Baldoni's team, featuring an amended complaint in this case, and also their version of a timeline of events in this story that featured never-before-seen text messages between Baldoni and Blake Lively and Baldoni and Ryan Reynolds. And we've dedicated several episodes of Sidebar to breaking those down. If you want to check them out, they're up on our Law&Crime YouTube page. But just to further this before we get into the major update, a spokesperson for Blake Lively and Ryan Reynolds said to Deadline also, quote, "We look forward to investigating more about Jed Wallace's entire business model and what else he was doing to distract from the very real sexual harassment and retaliation claims made by Miss Lively. We are delighted to be able to start discovery on it." Now, Jed Wallace is very interesting because he is somebody that Blake Lively initially named as a defendant in her first civil rights complaint that she filed with the California Civil Rights Division, but she didn't name him as a defendant as of yet in her official lawsuit. He ended up filing a lawsuit against her. His argument was, you first name me as a defendant, then you don't name me as a defendant. You defame me. You asserted false allegations against me. I had no part in this alleged smear campaign against you. She claims that he was one of the people who helped launch this digital army against her. The allegation was that there was a ton of negative stories and press and social media accounts that were all highlighted and amplified against her, and he was a part of it. So he has sued her for defamation. Actually, he's been seeking a declaratory judgment, meaning he wants the court to come forward and say, we looked at this. He is in no way a part of this alleged smear campaign against you. He wants a court to actually make that statement. I mentioned before, I think that's an uphill battle, but just to give you an idea, she wants to, look a little bit more into all aspects of this case. Hey, by the way, I got to tell you guys, since we're always concerned about personal safety and privacy here on the show, did you know that your personal data is being harvested and sold online by data brokers? Yeah, anyone can buy your personal details. And when this happens, you're at risk for a whole host of things like identity theft, becoming a target of phishing scams, potential stalking. But that is why I am so happy to tell you about our sponsor, Delete Me. So Delete Me helps you keep your personal information private. I use Delete Me. Honestly, crazy what I found. dozens of data brokers with my personal information, and it was listed on so many sites, so many listings. My gosh, but Delete Me removed all of that. And honestly, using Delete Me has given me a lot of peace of mind about my family too, because if someone buys your data via a data broker, they can also get information about your relatives too. So right now you can get 20% off of Delete Me and protect your personal data when you go to joindeleteme.com/sidebar. Use promo code sidebar at checkout. That's deleteme.com/sidebar. Promo code sidebar. So we want to move on to what is happening right now. So the lawyers for Baldoni and co. filed a letter with the judge overseeing this case, Honorable Louis J. Lyman. And they say they want to make the court aware of a discovery issue, namely what they call, quote, overbroad subpoenas. Their letter reads, earlier this week, the Lively parties issued subpoenas to cellular providers, AT&T, Verizon, and T-Mobile, seeking, quote, all documents concerning ingoing and ongoing calls or text messages related to phone number, and then it's blocked out, belonging to each of the individual Wayfarer parties, some of their employees, and various non-party individuals, including but not limited to call logs, text logs, data logs, and cell site location information. The subpoenas seek such information over a period of multiple years, in most cases spanning from December 1st, 2022 to the present. Now, what are they looking for? Keep that in mind. I'm going to get back to that in a little bit, but I will tell you, subpoenas in any case, but particularly this case, subpoenas for electronic records are so crucial. I mean, do we forget how all of this started when Lively filed her initial precursor complaint with the Civil Rights Department I mentioned in California? This was before she filed her official lawsuit. That complaint, and then the subsequent article that was published by the New York Times, featured bombshell text message conversations between Justin Baldoni and his PR and crisis management team, and also between them. And Lively claimed that these messages prove there was a plan to damage her reputation in the media, online, and in the public. And how did they get all of these text messages? Well, apparently they got these text messages, even though, by the way, that Baldoni claims these were cherry-picked and incomplete conversations. But they apparently got all of these text messages through subpoenas. Although, I will tell you, it wasn't entirely clear from where they got them, because according to Variety, though, her lawyers stated that they got the messages through a subpoena to Jones Works LLC. We'll talk about them in a little bit, but this was the company of a former PR representative for Justin Baldoni. She's engaged in her own separate litigation. I'll talk about that a little bit later. But Brian Friedman, who is one of Justin Baldoni's attorneys, he came out and said that none of his clients were actually subpoenaed, though. So did it all come from Jones Works LLC? I guess not entirely clear, but interesting. Anyway, you put that to the side. Once they got the messages, and look, they got the messages, then they launched this civil action. But let me be clear about something else. Those subpoenas were for the contents of those messages, right? We saw what those messages were. What's going on here is a little bit different. I want to continue on because in the letter it says, it is hard to overstate how broad, invasive, and atypical these subpoenas truly are. This is civil litigation, not a criminal prosecution, and the Lively parties are not the FBI. Yet the subpoenas seek not only the complete call and text history of each of the targets over a period of several years, no matter the sender, recipient, or subject matter, but also over the same period, real-time location information and data logs reflecting, among other things, web browsing history. This would include, of course, materials protected from disclosure by a laundry list of statutes and privileges, among them the attorney-client privilege, the spousal privilege, and the physician-patient privilege. Moreover, the information sought by the subpoenas is wildly disproportionate to the needs of the case and unnecessarily invades the privacy of untold numbers of third parties, including family, friends, business partners, and quite literally any other person with whom any of the targets have communicated with over a period of years. And then they cite Federal Rules of Civil Procedure 26, which limits discovery to, quote, any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. Yes, they cite that language, but there are two other components of that rule that I want to list out too. Also, you have to consider, quote, the importance of the discovery in resolving the issues and whether the burden or expense of the proposed discovery outweighs its likely benefit. And it also says, by the way, information within this scope of discovery need not be admissible in evidence to be discoverable. In other words, you can maybe get access to material during this initial discovery phase that you may not ultimately be able to introduce at trial due to, issues like privilege or relevance, prejudicial issues. The judge will ultimately determine what can and can't come in leading up to the trial. But the key is, not everything is subject to discovery. And if you're asking for something, what is the burden on the parties who have to respond here? So it has to be relevant, it has to be proportional, it has to be important, it can't be overly burdensome. The letter continues, quote, "Unfortunately, it appears that these subpoenas are more than anything else a media ploy, having been promptly leaked alongside a lengthy and combative statement by the Lively party's legal team." And they actually seemingly referenced the comments from Lively's attorneys, Mr. Gottlieb and Mr. Hudson, that I mentioned before. And honestly, even if that's true, kind of hard to blame the attorneys for making a public statement like that, given how public this battle has been and the numerous comments that Baldoni's attorney, Brian Friedman, has made in interviews into various media outlets. Although I will tell you right now, the court put on an admonition, a warning to both sides. Be careful about what you say in the media. Don't do anything that would prejudice this case in any way that might taint a future jury. But I will say, it honestly seems, though, that Baldoni's legal team doesn't really fault Lively's attorneys for making statements in the media, because they write in the letter, "The Wayfarer parties are not remotely concerned about the Lively party's public statement, however hypocritical, and do not object to their use of third-party discovery tools. The Wayfarer parties are using such tools themselves, albeit in a far narrower and legally permissible fashion." The letter continues, "However, the Wayfarer parties are deeply concerned that the Lively parties are intimidating third parties into providing information about our clients and various non-parties far beyond what is appropriate or even legal in civil litigation, including spousal communications, medical information, attorney-client communications, and real-time location information, among other things. The subpoenas constitute a flagrant abuse of the discovery process, and if allowed to stand, set a precedent that once their bluster dissipates, we are confident the Lively party's counsel will not be prepared to accept when it comes to the scope of discovery into their own clients' private information and communications." In other words, meaning wait till we subpoena Blake Lively and Ryan Reynolds' information. After all, what Baldoni's team has presented so far has just been his communications with Blake Lively, his communications with Ryan Reynolds, and his communications with producers, executives, his publicist, crisis management specialist, the apparent intimacy coordinator. But what about the conversations between Blake Lively and, let's say, her publicist, or Ryan Reynolds and other people? Now, I will tell you, communications between Ryan Reynolds and Blake Lively, since they're married, that may be off limits due to the spousal privilege. Those private communications between husband and wife, they may possibly not be disclosed. We'll see which way that shakes out. But going back to the letter, and this part is important because usually a court will say, look, before you come to the court to complain about discovery issues, discovery disputes, can you try to figure this out between you two? Can you try to figure it out between the other side? Here's what the letter states. Quote, "This afternoon, we conferred in good faith via telephone with the Lively party's counsel regarding the subpoenas, but were unable to resolve the dispute. This matter is highly time-sensitive, as certain of the cellular providers have already indicated they intend to comply with the subpoenas. The Wayfarer parties therefore request your Honor's attention at the soonest possible opportunity." Well, now we have a response from Blake Lively's side, her legal team. And unsurprisingly, as we have seen with all aspects of this case so far, we have a completely different view and characterization of what is going on. Here's the opening paragraph of their letter. Quote, "The Wayfarer parties have failed to meaningfully meet and confer regarding their objections before seeking intervention from the court and completely misrepresent the subpoenas that have been served. The Wayfarer parties' request to quash the subpoenas accordingly should be denied. The Wayfarer parties have sued Ms. Lively for a preposterous sum of $400 million for claiming, based on the Wayfarer parties' own communications, that a retaliatory campaign existed, yet now appear to fear having third parties turn over the actual evidence that would document the who, what, when, where, and why of that campaign. On February 12, 2025, the Lively Reynolds parties issued notices of the subpoenas to the aforementioned carriers, seeking non-content records, that is, numerical logs, related to 15 specific individuals. Each individual is either a party to this action or the related matter of Jones v. Abel, or is an agent employee of a party who appears, based on evidence discovered in this case, to have a direct connection to the underlying issues. By the way, the Jones v. Abel case that was just mentioned there, that is a separate lawsuit going on. So Stephanie Jones, who owns, as I mentioned before, Jones Works LLC, she was the former publicist of Justin Baldoni. She ended up suing him. Her former employee, Jennifer Abel, who acted as Baldoni's PR agent, she's actually a defendant in the lawsuit filed by Blake Lively. Melissa Nathan, this is Baldoni's crisis management expert, again, another person being sued by Blake Lively, but she's also a defendant in the Jones action. But here, Jones claims that, look, I wasn't a part of this alleged smear campaign against Blake Lively, and these defendants, Baldoni, Abel, Nathan, they conspired behind my back to do this, and they ended up pointing the finger at me and attacking me. But anyway, give you a side note, that's that separate action there. Back to the subpoenas. So Lively is claiming that these subpoenas to these communication companies are about 15 people who are either parties in this lawsuit or they are agents and employees of a party. So let's say, I'm just using an example here, if Justin Baldoni had an assistant, perhaps his communications with that person should come up, or that assistant's communications with a third party should come up. The paragraph continues, the requests are tailored to the time during which evidence shows each individual may have been involved in acts giving rise to Miss Lively's claims. Such information is not only relevant, but essential to unearth the network of individuals involved in the alleged retaliation scheme against Miss Lively. And to add a little bit more to that, so later on, and this is emphasized a bit more, it says, quote, the requested records will provide objective evidence on when and how the defendants and witnesses learned about Miss Lively's harassment allegations, and whether, when, and with whom the Wayfarer parties coordinated efforts to discredit Miss Lively through the press and social media. The requests are also tailored to key individuals and relevant time periods, may resolve core factual disputes, and are proportional. For example, the requests associated with crisis communications individuals who appear to have started their work on behalf of Baldoni and Wayfarer in 2024 are limited in time to a matter of months. In other words, our subpoena requests are for relevant, specific, and important information in this case. And though they don't give, specific details about what they're looking for, now we kind of get a sense of what they might be looking for. And by the way, during the course of discovery, you don't know exactly what you're going to get. You have an idea of what you're looking for, but who knows what might come from it. Well, from there, Lively's counsel goes into the allegation that Baldoni and co. did not actually meet in good faith as they claim. Remember that telephone meeting? They write, quote, it is clear that the Wayfarer parties had their letter motion prepared before even meeting and conferring, and they intended to file it regardless of what happened during the meet and confer. On February 14, 2025, at 4 p.m., counsel for the parties participated in a telephonic conference regarding the Wayfarer parties' objections that the subpoenas seek substantive communications, which they do not, are overbroad, and implicate third-party privacy issues. The Lively Reynolds parties repeatedly clarified that the subpoenas seek only non-content data, such as call logs, and that nothing in the subpoena could fairly be construed as seeking from third parties any substantive communications. Further, the Lively Reynolds parties requested legal authority to support the Wayfarer parties' position regarding their objections, including their standing to make such objections on behalf of third parties. The Lively Reynolds parties additionally offered a number of suggestions to narrow the scope of the requests, including supplementing the subpoenas to clarify the non-content nature of the requests, to narrow the applicable timeframes, and to limit or withdraw the request for cell site location. Counsel for the Wayfarer parties refused to entertain any proposal, instead demanding that the subpoenas be immediately withdrawn in their entirety. Okay, lot to digest there. In other words, they are arguing essentially, hey, Wayfarer, Baldoni, that whole side, you claim our subpoenas are too broad? Well, your requested relief, throwing these subpoenas out in their entirety, that is way too broad. And they also call out the Wayfair parties for the fact that they're not seeking a protective order here. If it's such an issue, why didn't you seek a protective order? In other words, a protective order is an order that prevents certain information from being disclosed or being turned over, or dictates the terms on how certain material is turned over, accessed. It limits the scope of what can be produced during discovery and so forth. But again, you didn't ask for a protective order. The gloves are off in the war between Blake Lively and Justin Baldoni, co-stars in the recent film It Ends With Us, who each accuse each other of harassment and retaliation. Lively's team has just filed an amended complaint, not only clarifying certain issues she brought up in her first filing, but now apparently revealing shocking new messages, behind-the-scenes stories, and the impact this whole legal battle has had on her career. We're digging into this full complaint with you right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Well, it is a dramatic new twist in the ongoing feud between It Ends With Us co-stars Blake Lively and Justin Baldoni. Lively's attorneys have filed a new bombshell amended complaint revealing fresh allegations of on-set misconduct, a retaliatory campaign aimed at discrediting her. Key witnesses now, according to Lively, willing to testify against Baldoni and his team. This 137-page filing expands on her claims of harassment and now includes new players added to the case. It just intensifies the drama surrounding this very troubled production. If we look at this in totality, and we're going to break down this full complaint for you so you don't have to do it yourself, I would say the big themes are new responses, new claims, and potentially new corroborating evidence. Let me get into it. Now, if you haven't been following what's been going on here surrounding Blake Lively and Justin Baldoni, just buckle up for a second. This all kicked off on December 20th when Blake Lively filed her civil rights complaint with the California Civil Rights Department, accusing her co-star and director of It Ends With Us, Justin Baldoni, of serious misconduct, including sexual harassment, creating a hostile work environment, and other boundary violations. And Lively claims that when she raised these concerns, she faced retaliation and a smear campaign designed to damage her career. And of course, she didn't just go after Baldoni. She also named his production company, Wayfair Studios, along with the CEO, Jamie Heath, Baldoni's former publicist, Jennifer Abel, his crisis manager, Melissa Nathan. And the very next day, the New York Times joined the fray because they dropped a bombshell article titled "We Can Bury Anyone Inside a Hollywood Smear Machine," which revealed text messages that Lively's team claims they got through a subpoena that apparently shows how deep this alleged smear campaign against her really ran. Baldoni, though, he fought back. He struck back in more ways than ever. On New Year's Eve, he fired back against the New York Times, filing a $250 million defamation lawsuit against the outlet and accusing them of publishing a misleading report with cherry-picked messages that only supported Lively's version of events. In his filing, Baldoni claimed that Lively's team was actually behind a smear campaign against him by weaponizing her claims to destroy his reputation and career. And he took a whole step further when on January 16th, he countersued Lively and her husband Ryan Reynolds, along with Lively's publicist Leslie Sloan, accusing them of orchestrating a campaign and also claiming that Lively hijacked his film in a bid to control his narrative. So now you fast forward to the end of January, and Baldoni's team took their claims even further and launched a website dedicated to this legal fight. That website, lawsuitinfo.com, includes documents related to his lawsuit, including an amended complaint, a timeline of events, according to him, dating back to 2019 related to the making of It Ends With Us. Again, never before seen messages were published. But of course, this only added more fuel to the fire. Her team ended up going to the court. There was even a suggestion about maybe a protective order needed to be put in place, specifically referring to Brian Friedman, Baldoni's lawyer. There was an accusation that he might be violating the rules of professional conduct here by making statements outside that could maybe unfairly prejudice a jury. Now, the two sides ended up meeting in court for the first time on February 3rd for a pretrial hearing. And basically, in the end, the judge said, don't make any comments either side that could affect this case in a negative way, that could prejudice this case, that could ultimately taint a future jury. Just be careful. Now, lawyers for Blake Lively have just submitted an amended complaint. That is what we're going to break down for you. Again, over 130 pages long. Now, one of the first things that we noticed about this lawsuit is that it adds more defendants, namely Jed Wallace and his crisis management company, Street Relations, Inc. Now, we have done separate episodes of Sidebar about who Jed Wallace is and how he got involved in this whole legal saga. You can check out those episodes on Law&Crime's YouTube channel. But basically, Lively claims that Wallace was involved in the social media campaign to paint her in a bad light following the premiere of It Ends With Us. Now, here's what happened. Lively had originally named him in her complaint with the California Civil Rights Department, which is a precursor to filing a lawsuit. But when she did file her official complaint in federal court, Wallace wasn't named as a defendant. And that's when he ended up filing his own lawsuit against her, saying, Lively name-dropping me ruined my reputation and ruined my company's reputation. But now he has officially been named in this amended complaint. He is the defendant in this action. And actually, by the way, it's interesting because Lively now claims that in this amended complaint, this is new information, that she tried to depose Wallace, but according to her, he allegedly evaded and obstructed her efforts to do so, and then she accuses his lawyers of misrepresenting what happened too. You probably could dedicate a whole Sidebar episode to that. Maybe actually we will. But anyway, also new, there are more causes of action in this amended complaint. The first lawsuit had 13 claims. This one has added 2, defamation and defamation per se, plus civil conspiracy. Big difference between defamation. Defamation per se is they both allege false statements that were made to another. And if you're dealing with a public person like a celebrity, you need to show actual malice, that you knew they were false or you acted with reckless disregard for the truth. But per se is basically saying the statements are so bad on their face, you don't even need to show how they're harmful to your reputation. It's clear. Civil conspiracy is a type of collusion involving an agreement between 2 or more parties to deprive a third party, of legal rights or deceive a third party to obtain an illegal objective. Now, Justin Baldoni's lawyer, Brian Friedman, told TMZ that this suit is, quote, filled with unsubstantial hearsay of unnamed persons who are clearly no longer willing to come forward to publicly support her claims. He goes on to say that Baldoni and Wayfair have been transparent in providing receipts, real-time documents, and video showing a completely different story than what has been manipulated and cherry-picked to the media. He also told TMZ, since documents do not lie and people do, the upcoming depositions of those who initially supported Miss Lively's false claims and those who are witnesses to her own behavior will be enlightening. What is truly uncomfortable here is Miss Lively's lack of actual evidence. Now, he might be saying that because if you look at her complaint, unlike Baldoni's, there seems to be maybe less text messages to document certain conversations, but she's still alleging it nonetheless. And with that in mind, let's dig into this complaint. So, Lively starts off by pointing out that the efforts that Baldoni has made in recent years to present himself as a supporter of feminist causes maybe doesn't add up. And I want to read you through a portion of the first few pages because it kind of gives you a good idea of what exactly Lively is accusing Baldoni of doing. The complaint reads, for years prior to the release of the film, Mr. Baldoni portrayed himself as a leader of the male feminist movement in writing books, hosting podcasts, and holding TED Talks on the topic. In reality, however, Mr. Baldoni's public persona is a stark contrast to his private behavior, which is replete with hypocrisy, misogyny, and retaliation. In public, Mr. Baldoni gave the appearance of taking responsibility for the fact that he had unconsciously been hurting and silencing the women in his life and implored men to be man enough to shut the hell up and listen to women. At his own moment of truth, when forced to confront women he had made uncomfortable on his own set, he trivialized their concerns and failed to take accountability for the effects of his behavior, whether intended or not. And when faced with the predictable consequences of having created a toxic set, namely that the cast did not want to appear alongside him in public rather than holding himself accountable, Mr. Baldoni hid behind his billionaire friend and retained publicists, crisis managers, digital media strategists, and litigators to mount a sophisticated and well-funded retaliation campaign that sought to bury and destroy anyone that challenged his brand. That campaign has succeeded beyond Mr. Baldoni's wildest expectations. The defendant's actions have created such a toxic climate of online vitriol against Miss Lively, her family, other members of the cast, and various fact witnesses that all of the above have received disturbing threats. One fact witness known to publicly support Miss Lively recently received a written threat indicating that the witness's family would be sexually assaulted and killed unless the witness agreed to make a statement and give the truth. This type of climate was the predictable, if not inevitable, result of the retaliatory campaign launched by the Baldoni Wayfair parties both before and after the litigation began. So, at multiple points in this complaint, Lively talks about other female cast members who were apparently uncomfortable with Baldoni's alleged actions on set. And that is key. Something that was alleged in the first complaint, but really expanded upon here. In other words, it's not just Lively who is prepared to speak out and accuse and possibly testify against Baldoni, but possibly others. Quote, this amended complaint does not refer to certain witnesses by name, nor does it provide screenshots of their text messages. By the way, this is something that Friedman had highlighted, the lack of text messages, but I guess if you're Blake Lively, you could be saying I'm trying to protect the privacy of these people. But she goes on to say, importantly, however, these witnesses have given Ms. Lively permission to share the substance of their communications in this amended complaint as contained therein, and they will testify and produce responsive documents in the discovery process, meaning at this stage she's not going to produce these text messages. Ms. Lively was not the only one who was uncomfortable on set, and Mr. Baldoni and Wayfarer knew it. The defendant's false narrative crumbles under the indisputable truth that Ms. Lively was not alone in complaining about Mr. Baldoni and raised her concerns contemporaneously as they arose in 2023, not in connection with some imagined power play for control of the film in 2024. The experiences of Ms. Lively and others were documented at the time they occurred starting in May of 2023. Importantly, and contrary to the entire narrative defendants have invented, Mr. Baldoni acknowledged the complaints in writing at the time. He knew that women, other than Ms. Lively, also were uncomfortable and had complained about his behavior. So the complaint highlighted messages that Lively apparently shared with other women with whom she commiserated about the alleged toxic set not long after filming reportedly got underway. For example, it reads, quote, on May 24th, 2023, Ms. Lively confided in a text to a woman who is a mutual friend of Mr. Baldoni and Mr. Heath, I was going to invite you to set tomorrow. These people, whoa. It's like HR nuts today, the both of them. I wasn't expecting that turn. I mean, it's been present, but today I came home and cried. Further in the exchange, Ms. Lively describes Mr. Baldoni and Mr. Heath as creeps. Like, keep your hormones to yourselves. This is not mine. I don't want it. I don't want your gaze or words or tongue or videos of your naked wife. Yeah, it's shocking. Clowns. Quote, a few days later on May 26, 2023, Ms. Lively reported her concerns regarding unwelcome and inappropriate behavior by Mr. Baldoni and Mr. Heath, the chief executive officer of Wayfair and producer of the film, to Sony employee Angie Giannetti, the film's representative for its distributor Sony Pictures Entertainment. Over the following 3 days in May of 2023, another female cast member reported her own concerns regarding Mr. Baldoni's unwelcome behavior to both Ms. Giannetti and one of the film's producers. Now, this is critical to Lively's claim, the idea that she wasn't the only person on the set feeling uncomfortable or that she was being targeted, that other actresses or other people said that they had some of the same issues. Quote, on June 1st, 2023, Mr. Baldoni responded to that female cast member in writing, acknowledging that he was aware of her concerns and that adjustments would be made. Notwithstanding that promise, Wayfarer took no actions to investigate this reported conduct, nor did it implement any protections at that time. Just 1 week later, on June 8, 2023, the same female cast member told Ms. Lively about her growing concerns with the conditions on set and that she found it difficult to talk to Mr. Baldoni. Ms. Lively responded that, I know I find it really hard to speak to him. I try to cover it with busyness, but not sure that covers what's going on. Later, another female cast member confided to Ms. Lively that she too felt uncomfortable on set. All of this occurred and was documented in writing almost 1 year before the editing of the film began. If there is that documentation and can be shown, that could be quite powerful. Or how about this? Ms. Lively shared that she needed to tread carefully to, quote, salvage some degree of chemistry and camaraderie with Justin, who's not only my director, but love interest, and we're not even a third of the way done. The two women then recounted their discomfort with their experiences with Mr. Baldoni and Mr. Heath, including one incident in which Mr. Baldoni secretly recorded them, and another in which he made an unwelcome remark about the female cast member's wardrobe. By the way, if there's a recording and that can be produced during the course of discovery, again, compelling evidence. It goes on to say, Ms. Lively noted that Mr. Baldoni once asked her if he crossed a line, and when she said yes, he made a joke that he must have missed the sexual harassment meeting. And then there's this, quote, Miss Lively and the female cast member discussed various examples of their uncomfortable and inappropriate interactions with Mr. Baldoni, and on May 28, 2023, Miss Lively explained that her concerns were not just with Mr. Baldoni's behavior, but the way that Mr. Baldoni behaved after being confronted with his line-crossing behavior. He keeps referencing it, or disconnects entirely, or gets snippy and impatient as a director. He was so huffy about the sexy thing, I felt awful for saying something. Again, big new accusations in this complaint. Now, I also said that this amended complaint is about responses, and I think we're going to probably do this more in a future sidebar episode, but Lively responds many times to Baldoni's explanations, his defenses. For example, do you remember when she says that Baldoni and Heath would invade her space, that they would come into her trailer unannounced, right? And he came forward and said, look, that's not true. She invited me while she was breastfeeding, right? Well, she responds to that in this complaint. Here's an example. Mr. Baldoni and Mr. Heath both showed a shocking lack of boundaries by invading her personal space when she was undressed and vulnerable. Defendants have claimed that these intrusions were Miss Lively's fault because she texted Mr. Baldoni on one occasion that she was, quote, just pumping in my trailer if you want to work out our lines. This misunderstands the difference between a woman pumping on her own terms, having taken the necessary steps to make herself comfortable, covering herself and ensuring the conditions are appropriate for the task, and walking in on someone without notice or permission while they're breastfeeding or otherwise in a state of partial undress. Now, let me go back to the timeline here. So many of Hollywood's writers, they went on strike in 2023 as part of a labor dispute. And that impacted a lot of productions, including It Ends With Us. And when the strikes ended and everyone was prepared to get back to work at the start of 2024, Lively had asked for certain protections for herself and others on the set. And the amended complaint reads, before returning to production following the guild strikes, based on Wayfair's complete failure to investigate or address any of the complaints conveyed by Miss Lively and others, Miss Lively decided to speak up and require that Sony and Wayfair agree to a set of protections to ensure a safe set for all of the cast and crew. Now, the protections to return production, they were attached as an exhibit. We've talked about these before. They include guidelines like there is to be no spontaneous improvising of any scenes involving physical touching, simulated sex, or nudity. But the last item in the document says that the production, quote, hold an all-hands in-person meeting before production resumes, which will include the director, all producers, the Sony representatives, the newly engaged third-party producer, BL, Blake Lively, and Blake Lively's designated representatives to confirm and approve a plan for implementation of the above that will be adhered to for the physical and emotional safety of BL, her employees, and all the cast and crew moving forward. And that meeting was apparently held in January of 2024 and included Lively and her representative, who was her actor husband, Ryan Reynolds. He's a defendant in Justin Baldoni's lawsuit. And Baldoni was there, Heath was there, the Sony representative, Angie Gianetti, was there, Todd Black, the producer, brought in to help oversee everything. The complaint says, importantly, none of the requested protections were tied in any way to Miss Lively's creative input in the film and were made months before any discussions regarding the cut of the film. At that moment in time, with the completion of the film uncertain, Miss Lively did not request, nor did she receive any creative rights, editing rights, credits, or any other role on the film beyond her roles as an actress and executive producer. The notion that she did all of this as some sort of Byzantine plot to take control of the movie at some future point, which she did not do in any event, is absurd, and there is not a shred of evidence to support it. That is important too. That's an important response because Baldoni has alleged that Lively bullied her way into taking control over the film and boxed him out, that she used her star power and the power of her husband, Ryan Reynolds, and even her friendship with mega celebrity Taylor Swift to do that. Now, Lively claims in this amended complaint that all of those accusations are not only inaccurate, but they're also irrelevant and a red herring to what really matters here, her allegations of sexual harassment and misconduct. There was one thing in Blake Lively's amended complaint against Justin Baldoni and others that really stood out. Her apparent responses to Baldoni's arguments and defenses. He has accused her of making false allegations against him, taking control over the film, and not accepting that she was at fault for her own career pitfalls. But now, Lively has responded, and she has counter-arguments. What did she say? What are her defenses? Let's talk about it. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Now, there was something in Blake Lively's amended complaint we didn't really get a chance to focus on a lot in our last episode when we broke down the whole amended complaint. But what we want to focus on right now specifically are the times when Blake Lively actually responded directly to the arguments, the assertions, the defenses put forward by Justin Baldoni and his team. More specifically, her counter-arguments to his defenses. And it kind of gives us a preview of what a trial will look like, right? Currently scheduled for March of 2026. Now, before we get into what she even had to say, I have to give you another caveat. We saw your comments online from when we posted the full breakdown of her amended complaint, okay? You have been accusing us of being biased. I get it. There's a lot of high passions here. There's a lot of people who have perspectives on this. A lot of people have feelings about it. I get it. Totally understand. Not judging you one way or another. But I've said this before. I'll say it again. We are literally trying to present both sides of this story. Some days we're going to present his arguments. Other days we are going to present her arguments. If we are breaking down her full new amended complaint, of course it's going to be focused a lot on her arguments. Doesn't mean that we're siding with her or siding with him. Today, specifically, we're going to be focusing on ways that she is trying to defend her actions. We are not taking a side, but I'll tell you what, no matter who you side with, you should know and anticipate the other side's legal arguments and evidence. You have to. So with that in mind, now we're going to get into this. And remember what is happening here, right? So Blake Lively originally sued Justin Baldoni and others, claiming that he sexually harassed her, engaged in misconduct on the set of the movie It Ends With Us, which he co-starred in and directed. And then she alleges that he launched a digital and media PR smear campaign against her that damaged her reputation, her businesses, caused her severe emotional harm, and that this was in the form of amplifying negative commentary online and negative posts and negative social media interactions and negative media articles. And by the way, she claims this was all because she vocalized her concerns about what was allegedly going on the set. Now, he fired back with lawsuits of his own, claiming that Lively and her husband Ryan Reynolds weaponized false allegations against him, tried to ruin his life, engaged in a coordinated campaign with the New York Times to publish what he claims was a one-sided hit piece against him. And in the end, he claims that she bullied her way into taking control over this film and boxed him out. Now, with all that in mind, we have this amended complaint. And we broke it all down in a previous sidebar. And as we discussed, it lists out new allegations, new claims, new messages, new defendants. Yeah, so Jed Wallace and his company are now listed as defendants. Lively argues he is a central figure in this retaliatory smear campaign against her. And now she also listed 2 new claims of defamation and civil conspiracy. Again, we talked all about that. But what we really want to focus on, a big component of this case, is her addressing and responding to a lot of Justin Baldoni's assertions and defenses that we've heard so far. So let me give you an example of what I'm talking about. Lively has alleged that Baldoni and Jamie Heath, this is another co-defendant, the CEO of Baldoni's production company Wayfair, that they engaged in a pattern of invading Blake Lively's privacy, that they didn't respect her boundaries, namely that they would walk in as she was undressing and she was vulnerable. And it's important for claims of sexual harassment in a hostile work environment, right? So what was Baldoni's response to that? Well, he said, I'll tell you what, Blake Lively was actually so comfortable with me that in June of 2023, after she alleges I had already engaged in alleged sexual harassment against her, she nonetheless invites me into her trailer while she's pumping breast milk. And by the way, I even have the text messages to prove that. And look, that's true. Lively appears to message Justin Baldoni in a text message, I'm just pumping in my trailer if you want to work out our lines. So this would suggest that perhaps her claims about being victimized and suffering sexual harassment, they don't quite add up. But Lively now has a response to that in her amended complaint. It reads, Mr. Baldoni and Mr. Heath both showed a shocking lack of boundaries by invading her personal space when she was undressed and vulnerable. Defendants have claimed that these intrusions were Miss Lively's fault because she texted Mr. Baldoni on one occasion that she was just pumping in my trailer if you want to work out our lines. This misunderstands the difference between a woman pumping on her own terms, having taken the necessary steps to make herself comfortable, covering herself, and ensuring the conditions are appropriate for the task, and walking in on someone without notice or permission while they're breastfeeding or otherwise in a state of partial undress. The critical distinction is consent. Miss Lively's one-time invitation was neither free license to join her immediately in her trailer, nor was it a general invitation to freely walk into her trailer at any time uninvited. And it certainly was not licensed to enter Miss Lively's trailer when she refused consent. The fact that Mr. Baldoni, who has repeatedly preached the importance of consent while giving media interviews or in public speaking events, now claims otherwise with respect to his own behavior, displays breathtaking hypocrisy. And that is the theme that is carried out throughout this amended complaint. If someone consents to one thing, it doesn't mean they consent to everything. Now, of course, she's still going to have to prove that he kept coming into her trailers and kept invading her space, but that's the central allegation. That's the central defense. And that becomes really significant when we discuss the improvisation of intimate scenes, another big factor in this story, because Lively has alleged that Baldoni went off script, that he improvised physical touching, that he added graphic scenes and contact, and that he acted totally inappropriately. In fact, at one point in the amended complaint, it reads, on May 24th, 2023, Miss Lively confided in a text to a woman who was a mutual friend of Mr. Baldoni and Mr. Heath, I was going to invite you to set tomorrow. These people, whoa, it's like HR nuts today. The both of them. I wasn't expecting that turn. I mean, it's been present, but today I came home and cried. Now, further in the exchange, Miss Lively describes Mr. Baldoni and Mr. Heath as creeps. And then she goes on to say, like, keep your hormones to yourselves. This is not mine. I don't want it. I don't want your gaze or words or tongue or videos of your naked wife. Yeah, it's shocking. Clowns. Now, if she can produce that text message that was made in real time, that could be a potentially key piece of compelling evidence, but again, everything is context in this story. Baldoni claims that it was actually Blake Lively who was acting inappropriately here. Quote, it was Lively who engaged in unchoreographed kissing scenes. One scene, again captured on camera, exhibits Lively pulling Baldoni in to kiss her. It is clear Lively was initiating unchoreographed kissing. In one take, she pulled Baldoni in and kissed him once, in another twice, and the number of kisses entirely initiated by Lively exchanged at her whim. Baldoni, as a professional actor who, among other roles, played the lead's love interest in television's Jane the Virgin for 5 years, is, like most actors, accustomed to rehearsing or filming scenes multiple times, often with variations, without needing permission while in character. While Lively now takes issue with any innocuous improvisation Baldoni, as Ryle, may have allegedly initiated while in character, Baldoni treated their relationship on camera as professional, each playing their part, each doing their job. If no one was supposed to improvise, Baldoni would have no way of knowing based on Lively's own actions. Lively demonstrated again and again that this was a normal and acceptable part of filming romantic scenes. In other words, he's not denying the improvisation, but he's saying she gave him the license to do it because she was doing the same thing. But again, Lively has a response to that in her amended complaint. It reads, the fact that Miss Lively varied the number of kisses in other scenes in which the kissing was scripted in advance does not justify Mr. Baldoni's improvisations or his attempts to add graphic sex scenes into the film. In other scenes, the kissing was consistent with the plot. It had structure and blocking, and most importantly, it was discussed in advance and was mutually consensual. There can be flexibility in such scenes, but it must be within appropriate boundaries. And the key is advanced planning and consent. Mr. Baldoni acted without planning, without consent, and grossly outside of acceptable boundaries. He made it personal and repeated even after Miss Lively spoke up and became defensive and dismissive when challenged, no matter how politely she mentioned it. By the way, so much of this case, if this goes to trial, is going to be his version versus her version. They're both probably going to have to take the stand and tell their side of the story with each one of these instances, by the way. Anyway, this now leads me to the different narratives, the different responses regarding the infamous dance montage scene, which we've talked about a lot here on the program, because anyone following the story will know exactly what I'm talking about. You see, Blake Lively has described in her pleadings that this was a prime example of Justin Baldoni allegedly acting improperly. And here's how her amended complaint describes it. Quote, on another occasion, Mr. Baldoni and Miss Lively were filming a slow dance scene for a montage scene, meaning that none of the sound recorded while filming the scene was meant to be used in the film. Music was intended to play over the action. Nonetheless, microphones were live to pick up room tone, but not conversations or dialogue to be used in the film. The scene in the script specifically described dancing without dialogue and did not include any intimate conduct or kissing. Mr. Baldoni did not provide notice or seek consent for any intimacy in advance. Instead, Mr. Baldoni chose to spontaneously improvise the scene while the cameras were rolling. During the filming, Mr. Baldoni repeatedly leaned in toward Miss Lively, attempting to kiss her, kissing her forehead, rubbing his face and mouth against her neck, putting his thumb to her mouth and flicking her lower lip, caressing her and telling her how good she smells. None of this took place while Mr. Baldoni was in character as Ryle, because both the intimacy and dialogue departed from what had been agreed to in the script. Miss Lively was uncomfortable and kept leaning away and repeatedly suggesting and then begging that their characters should just talk. She tried to use levity and creative pleas to deflect the unwanted touching, hoping to get through the scene in a way that maintained a professional boundary without antagonizing Mr. Baldoni. Now that is pretty consistent with what she has always been alleging. Now Mr. Baldoni responded to this by claiming that Lively was the one who broke character, that she wouldn't stop talking in the scene and he couldn't capture the shot that they needed, that she started talking about her personal life with her husband, Ryan Reynolds, that she was the one who apologized for the smell of her spray tan and body makeup, and that's why he said it smells good, that she was laughing during this scene, that she even made fun of his nose at one point. In other words, she wasn't uncomfortable. And to prove this, his attorney, Brian Friedman, seemingly released video of this scene to the public. Here's a sample.
And my nose is so big.
I was hoping that we could address this. It's not too late. Just gotta shut down. We gotta call an insurance month and just deal with that.
Yeah.
And then,
Cut.
Just kidding.
No, it's true. That's why we hired Jenny Slate too. Our nose is big.
But again, going back to Blake Lively and her new amended complaint, she has a response. She writes, quote, "The video footage of the scene shows Miss Lively to be trapped, having to appear as though her character was happy and in love while the cameras were rolling. Miss Lively did not want to film additional takes on the scene, but continued to participate to be a team player and support the production in real time while simultaneously expressing and holding physical boundaries against Mr. Baldoni's advances. Miss Lively even referred to Mr. Baldoni as a sociopath at one point during the exchange. Notwithstanding Miss Lively's attempts at humor and levity, her words, actions, and body language all evince her lack of consent. When Miss Lively later objected to this behavior, Mr. Baldoni's response was, 'I'm not even attracted to you.' In January of 2025, the defendants, through their attorney Brian Friedman, released this video to the media, apparently hoping that the mere act of releasing the footage would mislead the public into believing that it shows nothing abnormal or improper. But the footage by itself corroborates Miss Lively's description of the scene to the letter. That is not just Miss Lively's view. And that is when Blake Lively, in this amended complaint, references the opinion of Mia Schachter, an independent intimacy coordinator not connected to the production, who her opinion seems to be in line with Lively's description of events. And the thing about that is, we actually just interviewed Mia ourselves, and we actually plan to produce a full episode with our interview with her. It's going to be coming out this weekend, but here's a sample.
Right up front, they show you what it says in the script. It says they're at a bar, they slow dance, completely lost in their own world, I think. And there's no mention of kissing. There's no mention of kissing on the mouth, of kissing on the neck, of anything like that. So immediately when it starts, then we start seeing the footage, I just go, why is he trying to kiss her? It doesn't say that in the script. So that was a surprise and confusing and does, to me, scream unprofessional. As I said, if he wanted to see that, he could have said that and they could have had a conversation about it, in which she may then at that point have said, well, in that case, I think we need to have an intimacy coordinator for this. There wouldn't have been an intimacy coordinator present given the scene description, but if he wanted to add kissing, he can do that, but he has to have a conversation about it and say it before he does it. I think it's really easy for people who don't work in the entertainment industry to forget that actors are coworkers at their job. Like what we are watching in that video is two people at work. And you don't spring a kiss on your coworker. I think that makes a lot of sense in any other industry. You don't just kiss your coworker at your job. If your job requires that you kiss your coworker, which it often does for actors, that's fine, but you have to talk about it. So what I see in that video is like him having a vision and an idea of what he's going to do. And he's going for that vision without communicating it and without adjusting to the verbal and nonverbal information that she's giving him in that moment. I hear in what you read that she was trying to direct him, but what I see in there is someone trying to get out of something that is uncomfortable for her while being aware that dozens of people are watching and perhaps trying not to embarrass him in front of his own cast and crew. I also heard you say that that he says that he was getting notes about not being able to get the shot that they wanted. But it's clear to me that that has not conveyed what the desired shot is to Blake, because they're kind of having this like little back and forth on camera that we hear where they're not in agreement about what the shot is that they're trying to create together. He's trying to get one thing, she's trying to get something else. So clearly that was not clear. It was not conveyed clearly to her. I mean, what else I see in there is like, I don't see from the perspective of him as a director, he would have had to have that one kind of conversation. This is the vision, this is the shot I'm trying to achieve. From him as an actor, he could have said, I think our characters would kiss here, or I think my character would try to kiss you. And then given Blake the opportunity to say like, well, I don't want to do that in this scene, or I think then we need to bring on the intimacy coordinator, or I don't think my character would do that here. And then there would have been an agreement reached between them. But yeah, like if I were working on this and watching this happen, I would say to a producer or to an assistant director, hey, we need to hang on a second and have a conversation about this, because he's trying to kiss her and touch her in ways that we did not talk about ahead of time.
Again, that full interview with Mia Schachter is coming out on the weekend. We ask her a lot more questions because the legal fight centers a lot upon an intimacy coordinator. And I'll tell you what, actually, let's get into that, because that is another thing that Blake Lively responds to in this amended complaint. So at one point in the story, Blake Lively had demanded that before she returned to set after the writer's strike, she demanded that an intimacy coordinator be present basically at all times. She had made the claim that Baldoni improvised physical scenes, that there was no coordinator involved. Now, Baldoni responded to that, and he said in his own complaint, actually, an intimacy coordinator had already been engaged during the first half of production. It just so happens Blake Lively decided not to meet with this person, and he claims to have the receipts to prove it. Quote, contrary to Lively's knowingly false claims, it was Lively who refused to meet with the intimacy coordinator to plan out their scenes, putting Baldoni in the awkward position of meeting alone with the intimacy coordinator and later relaying sex scene suggestions and plans to Lively in the intimacy coordinator's absence. These meetings often took place at Lively's insistence in the couple's home, and often while Lively's husband was present. Lively's method of work was unconventional and uncomfortable for Baldoni. To suggest Baldoni was the one who created the scenario is knowingly false. And Baldoni incorporates into his complaint, a text message exchange. So first, it's a screenshot of a conversation seemingly between him and presumably Blake Lively, where he writes her, just hired intimacy coordinator who I love, will set you to meet/FT with her next week for intro. To which Lively appears to respond, I feel good. I can meet her when we start. Thank you, though. Now, Baldoni appears to send that exchange with him and Blake Lively to an unidentified female producer and writes, just FYI, and just wanted to tell you about this, seems she doesn't want to meet intimacy coordinator until we start, which may mess up the workflow, but I can still meet with her, of course. To which the female producer writes back, that's fine if she doesn't want to meet her now. You'll just have to walk her through what you and Redacted are thinking. Well, Blake Lively has a response to that as well in her amended complaint, and it reads, Miss Lively complained about inappropriate behavior as early as May 2023, which occurred without an intimacy coordinator present, and which ultimately led to Wayfair and Sony agreeing with Miss Lively that the consistent presence of an intimacy coordinator was not only reasonable, but essential. Contrary to defendants' assertions elsewhere, Miss Lively did not refuse to meet with the film's intimacy coordinator. She said she didn't need to meet with her before production started because there were no intimate scenes in the immediate future, so they could talk once production began. Miss Lively did have a call with the intimacy coordinator during preparations. Those conversations happened close in time to the filming of the relevant scenes. Elsewhere, Mr. Baldoni has blamed the intimacy coordinator for supposedly writing graphic new sex scenes, including foreplay and orgasms, and also talking about female sex organs. But Miss Lively consented to the sex scenes in the script as written at the time she signed on to the film. And Mr. Baldoni did not have consent to rewrite and add sex scenes, even if he did so with an intimacy coordinator. The purpose of the intimacy coordinator is to work with the actors to establish the appropriate boundaries based on what is in the script, not to rewrite the script and to add more sexual content to satisfy the director's demands. Now, talking about big central points in this legal dispute, aside from that, Justin Baldoni has claimed that he is the victim, that Lively inserted herself into the creative process, and that she ended up taking full control of the film, that she boxed him out, that she wouldn't even let him attend the premiere of the movie properly. Even embedded in his complaint are pictures of what appears to be he and his family and friends in the basement of the movie theater, while Blake Lively and her husband Ryan Reynolds and co-stars, they're upstairs, they're at the red carpet all together.